Thank you. If you'd call the first case.
SJC-11728, Commonwealth v. Timothy Cullity.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. The Commonwealth requests that this Court reverse the decision of the Appeals Court and reinstate the defendant's conviction for possession of a Class B substance because the evidence admitted at trial was sufficient to prove beyond a reasonable doubt that the defendant was in possession of the drugs found in the car in which he was riding. First, very briefly, the Appeals Court should not have ruled on sufficiency without first providing the Commonwealth with the opportunity to brief that issue, where that issue was not raised at trial, on appeal, at oral argument, or even in the defendant's 16L letter submitted after oral argument.
When you say it was not raised at trial, was there no motion for a Rule 29 acquittal?
No, there was not.
There was not?
No. And where the defendant did not move for a motion for required finding or raise the issue on appeal or at oral argument, even in response to a question on that issue, or in his 16L letter following oral argument, if that was a particular concern for the court, the court should have provided the Commonwealth with the opportunity to brief that issue. And that's particularly true here, where the issue raised on appeal related solely to the motion to suppress. So the body of evidence at issue in the appeal was the evidence presented at the motion to suppress hearing. The Commonwealth didn't cite to the trial transcript in its brief, didn't cite any evidence in the trial transcripts in its brief because it was unnecessary for the issues presented on the appeal. With respect to Your Honor's question, the defendant did, at the end of trial, argue in closing that the evidence had been insufficient to prove him guilty, but there was no motion for required finding.
That was to the jury. That was to the jury, or
it was a bench trial, Your Honor.
But it was more. You shouldn't, as a fact finder, find me guilty because.
Correct.
They haven't proved it beyond a reasonable doubt.
Correct. But there was no motion for required finding. As it stands, the appeals court decision requires the Commonwealth to fully brief the issue of sufficiency in any appeal that were to be filed in our office. Certainly, the Commonwealth has a duty to consider sufficiency when briefing any appeal. But where the issue isn't, as in this case, the evidence was sufficient to prove the defendant guilty, and it was not raised at any time by the defendant, the Commonwealth shouldn't have that burden, and therefore, at a minimum, should have been provided with the opportunity to brief the issue if it was of particular concern to the appeals court. Secondly, and perhaps most importantly, there was certainly sufficient evidence presented at trial to prove beyond a reasonable doubt that the defendant was guilty of the drugs that he was convicted of possessing. When the vehicle in which the defendant was traveling was initially stopped for a motor vehicle violation. It was a headlight, not a non-functioning headlight. The car was pulled over, and the trooper approached the driver's side window. The driver was not the defendant. The driver was a different person. The defendant was the front seat passenger. When he approached and the driver's side window was rolled down, he immediately smelled a smell of a freshly burnt substance. He testified that he was unsure what it was. It could have been marijuana. He wasn't sure, but it was a freshly burnt substance emanating from the motor vehicle. When he looked in, he noticed the defendant sitting in the front passenger seat. He testified that the defendant was not wearing his seatbelt, when he asked him for his ID, because he was not wearing a seatbelt, he seemed lethargic. It took him 3 attempts to get the defendant's ID, The defendant had watery, bloodshot eyes, and he was sitting in a lethargic way in the front passenger seat. The trooper took the two individuals' IDs, took them back to his cruiser to run the IDs through the MDT. Both individuals had suspended licenses, so the car had to be towed. He ordered the driver out of the car and took her over to his cruiser. He noticed that she was unstable, and on her feet she had watery, bloodshot eyes too, and she was eventually placed under arrest for operating with a suspended license and also charged with OUI drugs. When he returned to the vehicle, he noticed a partially burnt cigarette in plain view on the driver's seat. He testified he testified that it was a hand-rolled cigarette, not the type you would buy at a store, and that it emitted the same odor as the odor that had been coming out of the car. He then asked the defendant to step out of the car because the car had to be towed because there was no licensed driver. It took 2 requests to get the defendant to get out of the car. When he took the defendant out of the car and he sat him on the curb in front of the car, and then he conducted an inventory search because the car was going to be towed. When he did so, he recovered a plastic baggie containing 5 smaller plastic bags of a substance that the defendant stipulated was PCP, the Class B substance for which he was convicted of possessing. He also recovered the partially burnt cigarette, hypodermic needles, cotton swabs, and a spoon with burnt residue that he believed was drug residue. When he then placed the defendant under arrest for possession, and when he did so, the defendant was subsequently transported and booked for possession, and at the time of booking stated that he admitted that he had used PCP that evening. Now, it's important to know that the arrest occurred at 7 p.m., so that evening shortens the window of time in which the defendant had used the drugs. So
now the appeals court said it was unclear from the record when he had used the PCP.
That is a clearly erroneous factual finding. There was undisputed testimony by the trooper at trial that the arrest had occurred at 7 p.m., between 7 and 7:10 p.m., and there was undisputed testimony that the defendant had admitted to using PCP that evening. And that, again, is a reason where if the appeals court had requested that the Commonwealth brief the issue, the Commonwealth certainly would have pointed to that evidence as part of the evidence that led to a sufficient finding of guilt. I'm not sure, I don't remember if that precise testimony was in the motion to suppress, but it was very clear from the trial transcript, and had the Commonwealth been called upon to brief the issue of sufficiency, certainly would have pointed the court to that evidence. So this is not a case of mere presence. This isn't a case where a defendant is found in a car or in an apartment, and it's just mere presence with contraband in the same location. This is a case where we have the particular links between the defendant and the contraband that he was convicted of possessing. The court
I take it the intent to control, you say, is a reasonable inference to draw from the fact that he had smoked it or used it that evening.
Certainly, to be drawn from a couple of facts. Number one, he admitted to using the same kind of drug that he was convicted of possessing that evening, so it shortens the window of time. When there is also the evidence that there was enough drugs left. There were still drugs to be used, so he hadn't used the entire supply of the drugs.
But he wasn't the driver, and there's 2 people in the car. So I mean,
correct. But the inference is also that they were sharing the drugs. They had shared the drugs in the past, and the inference is they would continue to share the drugs.
Because both of them seemed to be somewhat incapacitated. Is
yes,
that why
and
you say
she
that
was. Yes, and she was charged.
Did she admit to having used it also?
There was no testimony to that effect at trial, but she was charged with OUI drugs. And so the inference is that he had used it that evening, that drugs remained, that he had the instrumentalities within the needles and cotton swabs were found in the footwell of his seat. The cigarette was found in plain view on her seat, and the drugs were found within inches of his reach. So on that evidence, there was certainly sufficient evidence.
How does one use PCP? I mean, how do you ingest it?
I see that I'm out of time. May I answer that question?
Yeah.
This was not something that was testified to at trial, but the Commonwealth looked into this issue, and it can be ingested through smoking, injection, or ingesting it.
All right, thank you.
Thank you.
Thank you.
May it please the court, my name is Jin-Ho King, and I am here representing appellant Timothy Cullity. We ask that the court find, as the appeals court did, that there was insufficient evidence on the element of intent, the intent to control the bags of PCP that were found in the car.
You didn't argue that, though, correct?
That is correct. That is something that we did not raise in the appeal, but I think the case law is clear that we cannot let a conviction stand where the evidence is insufficient. And I think here the evidence was insufficient as to the element of intent.
But I thought that the Commonwealth's point was, I mean, they would agree with what you just said, but they're saying, you got to give us a chance to at least dispute the issue.
Yes, and I think that in this court now, the Commonwealth has had the opportunity to dispute the issue. In fact, they've had the opportunity to brief the issue as well, fully. We actually filed a motion to brief the issue before this court, and the Commonwealth, as they should have, filed a brief as well. And so this issue is now fully briefed before the court. We ask that the court actually reach the merits rather than resolve the case without reaching the merits.
So your sister says that the fact that he appeared to be on PCP, combined with admitting that he had taken it that evening, and the presence of it right in the area between the driver's seat and the passenger seat is enough to provide a sufficient basis. Why is she not right?
Well, I think that the key here in this case is that there needs to be a connection between all of those facts and the specific PCP who was charged with possessing the bag with the small baggies inside that were in the compartments between the driver's and passenger side seat.
You mean there would have to be some evidence that would suggest that the PCP that the defendant had consumed earlier that evening would have to have come from that same sample that was in the car?
Well, so I think that this is actually a tricky area, because if they are charging him with constructive possession of that bag of PCP, then I think, yes, the answer is clearly there needs to be some connection, some evidence tying him specifically to that bag. If they are charging him, which they didn't charge him with, actual possession of sometime earlier of some other PCP, maybe PCP that was already consumed, then that's a separate question, and there wouldn't need to be that same connection to that specific bag. But because the Commonwealth chose to charge him with possession of that bag, constructive possession, I should specify, because this was a constructive possession case. This was not an actual possession case. They weren't saying that there was this actual historic possession. They were saying that at the time of his arrest, at or around the time of his arrest, he constructively possessed the bags that were found near him. Again, he was merely a passenger in the vehicle. He was not the driver. There were other things found in the car, like the spoon, with what the officer testified to was appeared to be burnt residue on it. There were needles, caps, but...
And where were they found specifically?
So the spoon was found near the driver's seat. The needles and cotton swabs, those were found kind of scattered throughout near the passenger side seat behind the driver's seat. There are also other things found that seemed clearly to be owned by the...
When you say the spoon was found near the driver's seat, I take it there's not much space between the driver's and the passenger seat. What do you mean by that?
I believe that...
Inch nearer the driver than near the passenger? I mean, what?
I think within the driver's seat well, yes.
And when you said the needles scattered throughout in the passenger seat, and then you said behind?
Behind the driver's seat.
Not in the right side passenger. Where?
Right, so
Not in the passenger in the front seat.
Sorry, I believe the testimony was that it was in the well of the passenger side seat and behind the driver's seat as well.
Okay, both those places.
Yes, both those places. And because this was not the defendant's car, I think there needs to be something more than just his presence in the car to connect him with that those other items found. And to then use that link to then try to link him to these bags of PCP that were found.
Well, but besides that, you've got him admitting that he's used PCP that evening, right?
Right, and I think, again, that goes towards the historic actual possession rather than possession necessarily of...
Well, not necessarily, but it's a reasonable inference. You
I
don't
think-
have to accept it, but a fact finder couldn't a fact finder?
I think that a fact finder, a reasonable fact finder could not have, because there are several inferential leaps that need to be made to reach that point. And before that's even approached, there are other inferences that are even more likely that would require that to be a not guilty finding. I think that certainly if there's an inference that the defendant used PCP, certainly that you would need to draw inferences that he used some of the implements in the vehicle, but there actually wasn't any evidence necessarily that, for example, the needles were used. There was no testimony that the residue on the spoon itself was actually PCP or related to PCP or smelled like PCP, even though there was a lot of testimony about...
It can be smoked, yeah?
Yes, yes.
And there's a cigarette or some kind of...
Right, exactly. And so there was a cigarette, but then now there needs to be some kind of inference that the cigarette was made using that PCP found. And yes, and so there are a lot of inferences that need to be drawn together.
Is there any information in the transcript about the quantities that were in the bag and whether or not some bags, did you say there were smaller bags inside of a bigger bag?
Yes.
Were they all uniform, or does it look like some had perhaps been consumed?
There was no testimony to that effect. And so without...
Were the drugs admitted in evidence?
The drugs were admitted into evidence.
So the fact finder could look at them and see?
Yes, the fact finder could look at them and see.
I don't know what it looks like. Is there any description of there must be a process in which it gets to the point where you can smoke it. I don't know what it looks like before you get to that point. What did it look like in those baggies?
It's a grainy brown substance.
That's what it was here?
Yes. The bags, there were 5 bags inside a larger bag, and there was this grainy brown substance inside. Again, there was no testimony as to any discrepancy between the sizes or the amounts in each of these bags. And in fact, there was no testimony at all that it looked like the bags had been tampered with in a way that would suggest use of that PCP. Again, I think there could be a reasonable inference that there was use of the cigarette. I mean, certainly the smell, the odor, that would imply knowledge, and his intoxication or apparent intoxication, that could suggest ability and intent. But certainly, if we're talking about possession of the bagged PCP, that requires further links that I think the evidence just doesn't show here.
And just to be clear, the cigarette was tobacco.
No, we
The
don't know
cigarette
that.
was,
The cigarette, it's unclear exactly
what was in the cigarette?
Yes, there was no testimony as to specifically what that cigarette was.
But it
The
wasn't,
one-
it wasn't a commercial cigarette, correct?
Correct, correct.
It was hand-rolled or something.
That is what the testimony was.
You would put the grains into the hand-rolled cigarette paper with some other thing?
Presumably, yes. That is how it could be consumed. And the one bit of testimony that was tying that cigarette to the PCP was the odor. But again, that
Are you arguing that there isn't enough evidence of constructive possession? I mean, because it seemed like the appeals court, the fact that the one thing the appeals court felt there wasn't sufficient evidence of was intent to control. There was ability to control,
Yes.
right? And that's what you're saying too?
that is what I'm saying as well. That there wasn't an intent to control the bags of PCP found between the seats. I see that my time is drawing to a close. We've briefed the issues very fully, and we ask that the court reverse the conviction. Thank you.
Thank you, counsel.